Greetings, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, and loving life. Coming at you tonight on subrogation and usufruct. And we've got John here with us again tonight. And before we get started, just one last reminder, please hit the like, share, and subscribe button. There's a PayPal link down below for anybody that wants to share some love. Always appreciated. And then, of course, the StreamYard link is down there for everybody that wants to join the panel. And we're going to talk tonight about something that many people just aren't familiar with, and that this system is a usufruct, and it's a subrogated usufruct. In other words, somebody gave something to somebody else to use, and in that giving, the rights, titles, and interest to that property were not conveyed to be returned. It wasn't conveyed for just use, it was conveyed for ownership. And so the system believes that it owns certain things, which is only a portrayal through a name. And that's the problem. They're using your name. They are the usufructuar. So in that, they turn around and use that name and give you a card authorizing you to represent them, where they use your name for their commercial purposes. Okay? So we're going to get into it with a short little video here tonight from a friend on YouTube, and he certainly knows what he's doing. And so we're going to start out with a short little, I think it's about a 6-minute video that he did on subrogation. And then we're going to get into some definitions. And this here, if you want to go check him out, this is New Day Rising. New Day Rising. And actually what I'll do is I'll just copy the link and drop it down for everybody. And go over and check him out. He's got a lot of good information. He puts out some really short videos, but he also does CDs and stuff that you can get from him for a nominal donation. But again, great information, and we're going to get into it as he talks about subrogation. I guess it's about a 10-minute video.
Happening today, guys. Hey, have a very interesting subject today. A lot of people talk about subrogation, but nobody really has a lot of answers. So today I'm offering a couple of CDs about subrogation. Very well put together, super good explanations, audios that walk you through everything, basically a step-by-step thing. Now, what subrogation really is, and I think people get confused. They think they can just walk in there and say subrogation and the court's going to do whatever they wish. Well, you have to do your homework, and this is a very good place to start because this has a lot of answers, if not all the answers. And this can be done basically on any computer. You insert the disc and you go step by step and you read and you listen to the audios and you take notes, you know, the normal way to research things, but this has all the goodies. So let me give you a little idea about the subrogation. I'm going to read this to you, okay? In its simplest terms, subrogation is a natural act where the administrator of an organization, a flesh and blood man, or an administrator of fiction. In other words, if you're not responsible enough to understand you're a flesh and blood man or woman, then they take over and administrate the body.
And this is what they talk about when you go into court, and the first thing they ask you is your name, Keith Little. If you don't know yourself, you're going to say, yeah. Instead of saying, no, that would be the name of my person. I'm the living soul in the form of a man as a child of God, and he is a respecter of no persons. Start clarifying this stuff so that they know that you know who you are. And remember, folks, in all of the discussions about God's name, never once is it distinctified as being a last name, first name, or anything. It's a name. And in this fictional commercial world, we have different forms of names that are conjunctive with last names, family names, and such as that. And this is the fiction. The name is the fiction. It only describes as a noun a person, place, or thing. The thing itself is the concrete thing that can be smelled, touched, tasted, heard, and whatnot, seen. Whereas the abstract nouns are the ones that exist in paper only.
And they do it to you because you don't have any skills and you didn't do any research. Okay. To settle all charges against the organization, he has assumed charges of whether assumed by nature or law, by passing the charges to the obligor, the person whom has promised to discharge the charges. And that's why you get in trouble. And a lot of people, their method of operation is throw everything against the wall to see what sticks.
And that's what I did in my last case. I didn't know exactly what I was doing back then. And I assure you, the research is pertinent.
Now, that's not the proper way to do it. Now, if you study everything and you understand what you're doing and you do a basic, simple thing that settles the matter instead of making it snowball. Now, for the last,
So when they ask you your name, ask what if that's your name, you settle the matter right away by rebutting the fact that the name belongs to the person and the person is a character of yours. Again, it's a usufruct where they're using your name, and then through subrogation and that signing of the SS5 and the enumeration at birth, all those signatures, you're handing over, without a qualified signature, you're handing over rights, titles, and interest in the property of the name, and then they attach an account number, put it on a commercial piece of paper known as a Social Security card that is used to obtain money, property, labor, and services on credit, and then you are the representative authority or authorized representative to use that account. So that puts you through subrogation, the usufructuary, where in fact they were the original usufructuary, and through that through the rogation, you have now become the usufructuary, and that's why you need to subrogate the usufruct.
40 years that I've been in.
And again, this is just different terminology for correcting the record.
Involved in stuff like this, everybody wants to snowball. They want to make it worse and worse and worse, and they don't show up for court. Next thing you know, they got another charge, for failure to appear, and then they do something else stupid, and they got another charge, and that's snowballing. That shouldn't be done.
And again, this is one of those things where I'm going to make it paramount that signature is everything. The signature and the form of the document. When you realize what those commercial papers are and how they work, and learn how to endorse them properly, you're going to have a better result. And this is a private communication. You don't go into the courts. When they give you a citation or something, you do so. You give them the correction in private to let them know. This is, of course, in order to help sustain the state's budget, to prevent them from going forth in a unlawful manner. Okay?
You should think, and you should get things to the beginning of the case. It should be solved, not trying to solve it at the end of the case. Now, in all of my studies, I really come to understand that approximately 30% through the court case, or the third inning of the 9-inning football game, because that's what it is. It's a game. They're going to put in GSA bonds and they're going to monetize the case. And almost anything you do is not going to cause you to win. It's going to cause you to look worse and worse and worse, like you don't know what you're doing, because you don't know what you're doing. Start from the beginning. Understand this before you get in trouble. I don't want to deal with anything at the end of the case anymore. They've put in everything they possibly can put in, stuff that everybody tells them to do instead of that.
And when it comes to those bonds they're talking about, guys, what's going on is that when you sign those citations, like I said, that's a usufruct where you're signing without a qualified signature. They're going to, in usufruct, use your information to create the bonds, but then they put the bonds in their name. Okay? So if you don't qualify the signature, they get to use the information. That's the property. That's the intellectual property that you gave them, and that's rights, titles, and interest in that property. And that's what they're doing. They get to use that property that you gave them, which is the data elements, including the signature, to transfer the bonds, but they get to do so in their name.
Them getting educated and understanding what they should do. Okay. Second part of this, we're going to make it even simpler for you to understand. Okay. Through the process of conventional subrogation, you as the executor. Now, I've been teaching the executor stuff since I started on YouTube over 4 years ago. Simple, basic, be the executor or the executrix.
And again, it's very important to learn the terms and stuff. And I used to say that as well. I didn't stick on it very long because I realized throughout all of the jurisdictions, they use a term, directive and director and this and that. So you're supposed to give them directions because they're not following the proper routing. And that's what it's all about, the proper routing. In order for credit to go out and return, you have to have that proper routing. Otherwise, it goes out, it embellishes the system, and that's why we end up with this beast system.
And settle the matter. Okay? You can't just pick it up one day and say, okay, this is exactly what I'm going to do. You never did any study, never did any research, and that's what this is about, okay?
Yes,
so through
research.
The process of conventional subrogation, you as the executor or the executrix, organization becomes the.
And again, in equity deems the beneficiary as the true owner. And it's the true owner that comes forth as settlor to settle the estate that's in probate of a public issue so it can be resurrected. It's a salvation process because that person has been condemned. That's what those instruments are. They're condemnations. And that's from the root of the urban development condemning the land for its natural use so it can be used for commercial purposes. It all goes to the estate, and whether it's out on the sea or if it's been landed, as long as that estate is in Admiralty Maritime and not private. If you don't have your private relief law, it's public. The only way to get a private relief law is common law, which was merged with equity. So again, it's not a matter of executor or executrix. It's a matter of settlor because it's not supposed to be in probate. Probate issues are dealing with executors and executrix executing the last will and testament of the testator who has passed on. So executor, executrix is in the matter of a probate issue, but it's on the private side. So again, it's not a matter of a living estate. While you're still alive, you come forth as settlor. If you're going to come forth as executor or executrix, it would be in relations to your father's estate.
Keith, may I ask a question?
Sure.
Greetings to all.
Greetings,
Um,
Iman.
greetings to all. The question, Iman. The question that I have is that it was an experience somebody had informed me about. Their parents had transitioned back in the 90s, and the mother transpired first, and then the father, and he was the last before the mother passed form. And so what happened was the estate for the father, at the time, the woman was trying to explain to me, went into probate through the courts. So if the estate was probated through the courts, and then further property was forced to be sold, quote unquote, does that mean that going forward, that the children coming forward, because they did not um, execute anything on the probate side after the decease of the parents, that they are now the settlers? Can you explain that to me?
No, they are the executor or executrix claiming an estate from their parents. In probate situations of your own estate, while you're still alive, it's not supposed to be in probate. So you don't execute, you settle.
Okay, so how would one know that their estate is in probate at this present time? And how
All
would one
courts,
go about
all courts,
settling?
all courts, as a matter of corporate structure, are probate courts.
Okay, okay.
See,
So, so
when you understand private estates and you execute the last will and testament of the testator who has passed on, it's a private matter, not public. So you
so
use
you
the courts. So you use the courts to administrate through um, making sure that the will is being executed correctly. Only you don't hire attorneys to represent. You hire attorneys to write up documents and file them. That's it, and that's all done in private. You don't go into court to do this stuff.
so one has to to find an attorney to draft up documents
Not not necessarily. If you need one, then do so. But
okay.
if you're competent of executing the estate, then you can do so. And that's just a matter of knowing how probate executions work. See, when you
Okay.
when you execute a probated estate or execute a state, if you need to do it through a probate administration because you're not competent, that's when you would hire the attorney to draw up the documents and stuff according to the last will and testament, not according to the executor or executrix. They're basically uh, executing the will according to the will, and that might need some legal technicalities. But again, if you're competent of those legal technicalities, you don't need attorneys to write them up and file them. You would
If
only
someone if
know.
someone has a will, and the people that was listed in the will, in the event of an accident or incident took place, but they are no longer, and the will is just in the name of the party who the will was created, for the benefit of handling financial affairs. How would someone go about instituting, or not instituting, but initiating that particular will? For instance, example, mother and father passed on, daughter married, And then, and so what happened is husband and wife created a will, husband passed on. Now there is the wife who has a will, but everybody that was listed in the will, they have also passed on. So does that void out the will?
No, the will is a standing document. It is a testimonial, and it stands in law because the testator wrote it, and he is a witness, and nobody can refute him anymore. Now that
Oh,
he's passed on, that's why they call it the last will and testament.
so is the testator the male party?
Either one, either one. If a female has an estate, she would be the testator. She's the one giving testimony. That's her last will and statement, will and testament.
Okay, and
Yep.
with the recent kidnapping going on, aren't they utilizing um the information that they gather from parties, from people, from men and women, to be able to try to tap into these estate, and how is one to protect that from happening?
Absolutely. Absolutely. And that's that qualified signature. You have to learn what a qualified signature is, and you have to understand that every document that they give you has potential for commercial use. And in that, you have to protect your rights, titles, and interests to the person and it being used in commerce.
So if one is using 1-308, all rights reserved, without recourse, does that protect them in any way? Or because the other code,
It, it,
3-402, that
it,
says,
it protects your interests of being violated only. In other words, if you sign without qualifying it properly, they still get the rights, titles, and interests, and they get to use it for themselves, but they can't come back and charge you for any kind of um, interest, charges, debts, anything. That's what the without recourse is. But to
okay,
qualify that, even further, you have to place a pay to the order of, and then name the specific entity that is to be paid by or paid to, and then qualify it with your signature by, and then your name. And we'll go over that some more in future videos. But for now,
okay,
we just want to concentrate on the subrogation and usufruct and how it happens. Then we'll concentrate on what you can do to fix that.
okay. So then the code 3-402, as far as signatures being placed in the on the instrument, for a place on the instrument for the signature.
For the person in the
Yeah,
instrument,
right. So
right? And it's
that
saying that,
that would make it a
and,
wash too, correct?
correct.
Okay.
It's stating that you're not taking on any liability. You're still transferring the rights, titles, and interest in the property if you don't qualify it correctly, but you're accepting that there's no liability to you, and they have
Correct.
to accept that too.
I yield. Thank you.
Holder, administrator of the charging instrument. You would be called the subrogee. You, as executor and administrator, can then impose your will. This allows the subrogee to be able to do these things. Use the charging instrument itself as a commercial paper to discharge the charges through the United States, who is the grantor. Forgive the charging instruments, rendering the charges void. Did you get that? Rendering the charges void.
So again, it renders the charges void, but they still get to use your name and information for their investment, again, if you don't properly qualify that signature.
Because Keith, is that because they're utilizing that as the obligor and changing it to the firm name so they can do the utilize the transmitting utility?
Absolutely.
Okay.
So why does everybody want to do these complicated things? It makes no sense. Okay. Number 3, settle the charges using negotiable instrument as executor and cash the charging instrument for the benefit of the estate that they've charged you under. The court enforcement to seal your estate records, effectively conveying the records to private executorship and not under probate. Listen, people, every office in the courthouse is probate. Yes, they're probating you. They're probating.
And that's what I just said. Everything through courts, because it's a commercial administration.
Registration.
It's administrating of probated estates, fictions, decedents. And if you're still alive, you are not the decedent. The decedent is the person, not one's self.
And that person is the record, is it not, Keith?
Correct. The individual's name and number identify the record. Absolutely.
Probating the land, they're probating the children, they're probating the cases, they're probating everything. That's your estate. You know, yes, they're tricking everyone. Yes, but you should understand. Go and check this out. You know, for a reasonable donation here, you can get these CDs and I get them out to you the same day. Okay. Now, understand that, you know, if the things that it's possible for you to do, you know, and if you fail to invoke your absolute right of subrogation by simply invoking it and prosecuting the settlement as the true creditor, so you're going to be the creditor. Okay. And then by subrogation, accept the knowledge that you are willing and able to administrate the organization at law. Then demonstrate the capacity by prosecuting the settlement by discharge and the charges at law. You're going to make this all go away. You know, it ends up being a nightmare. And I talk to a lot of people that it's a nightmare because they didn't understand when they got involved. It's a terrible thing because the court speaks a language and they make it up as they go sometimes. But subrogation and the information on these CDs can get you seriously far ahead. It can, you know, and this is not for criminals. This is for people of sound mind, people that want to do the right thing, people that want to get educated, and the people that want to have standing and they want to be able to go in there and whip their ass.
Not a want it, enough to
Because with
stand.
this information, this is how awesome this is. This is so good that they can't make you do anything. You do what you have to do for subrogation, and you listen to this stuff, and you look at the documents and the actual tips and documents that are associated with subrogation, and it's all in here. Yes, it can be used in any computer. If you don't have a drive, just buy a drive at Staples or Office Max or Best Buy and plug it in. It's like $30 for that drive, the people that don't have a drive in their computer. It's such good stuff. I'm offering this for a donation today. I believe in this so much that I'm going to give a discount for this and get this out there so people can get some get back. You know, that's what it's about.
And when he's talking about people can get some get back, it's talking about that credit thing. Again, credit goes out, it's supposed to circulate back to source. And if you're the one that's actually doing this stuff, again, you have to blame yourself in order to receive that credit. You have to see that it's coming from you. Otherwise, you will never get the credit because you're going to keep blaming it on everybody else. You have to be of sound mind. And that means you have to acknowledge your fault in it and you have to correct your part in it. In so doing, you have to repent. And that means you will change how you do things from now on. You will try to improve every day instead of just sitting there on a couch eating that conglomerate of food and poisoned drinks, watching somebody else's drama or comedic life on a boob tube because yours is so wonderful. You have to want it. You have to get up and do something about it yourself. And that means you have to accept your part in it.
Is not looking foolish, not looking stupid when you go in there, you know, and hopefully you don't have a court case. And if something does happen, and it's liable to happen, you know, the system can have their way with you. They do it with people every day in every county in this country. You know, start getting educated. And this is the power. Take back the power.
Absolutely. You have to take back your power, and nobody can do that but you. And Daddy's GPT says so one can turn the attached portion of a bill into a bill of exchange simply by endorsement or proper qualifying. Absolutely.
Yes, that is true.
Credit card under 15 U.S.C. 1602 is a card, plate, coupon book, or any device used to obtain money, property, labor, or services on credit. Under 7 U.S.C. 2012, as we discussed last night, it says coupon means any coupon, stamp, type of certificate, authorization card, cash, or check issued in lieu of a coupon. And you can ask any financial supervisor or director if the billing statement you get, it has a coupon on the bottom. It's got a little dotted line. It says, and they tell you to tear off the portion below and send it in with your payment. That's a coupon. And a coupon, again, a coupon is any device used to obtain money, property, labor, or services. So if you're using that coupon to obtain services, and it's a device used to obtain that service, then it's supposed to be done on credit. In case you didn't understand that, a credit card is a card, plate, coupon book, or any device used to obtain money. Mm-hmm. So why are you using money to pay when you can use that coupon and properly endorse it? Why are you going to the bank and writing a check to add with that coupon? That coupon is the credit device.
Exactly. I was just going to say that, Keith. And in some of my studies, I'm realizing, which I knew in the past, in many years ago, what I heard about the coupon is that you would actually endorse it and return it to, I think it would be the business or whoever send it out to you. You will return it to them, but wouldn't you send it to the CFOs or the CIOs?
I believe in my recent studies it shows that you're supposed to send them to the Bureau of Fiscal Services.
Okay.
Not complete on that yet. I'm still doing my research, but like I said, we're getting close, and one of these days, people are going to learn how to do this. And that's why I'm standing up. Again, it's not for me, and it's not for you. It's for the future generations that need to know this so we can stand up in competence and not enslave those children. Those are our primary duty. If we are here to tend to the earth's animals and minister the gospel to each other and them, then that's, our ultimate duty. And those are all of God's creatures. Like I said, I am a child of God. Even though I'm 58 years old, I am still that child of God. I don't have a grandfather in heaven, and he has no grandsons. We're all of his children, period.
I co-sign that, Keith.
So the next one, Investopedia. What is usufruct? Come on. There we go. What is usufruct? With property use and example. What is a usufruct? A usufruct is a legal right accorded to a person or party that confers the temporary right to use and derive income or benefit from someone else's property. So mom gave them a name, and that was the property that they're using. Okay? They took that name and they attached it to one of their accounts. Then subrogated everything and gave you a card to use on credit, but you're never taught how to qualify the signature so that it is on credit. You're never taught how to qualify the signature so that credit goes out and comes back to you. It is a limited real right that can be found in many mixed and civil law jurisdictions. A usufructuary is the person holding the property by usufruct. So again, mom gave them a name. They are holding that name in usufruct. They attach it to a number and then give you a card, and now you are holding their property in usufruct. There's a usufruct going on the usufruct, and this is why it's called subrogation. And we're going to get into subrogation and letters rogatory.
And Keith, my definition here, this is from Barron's, is that it's in civil law, the right to use and enjoy property vested in another.
Yes, it's an investment. Mom gave the name, and that's what I said. It was It was the start of an investigation because it came with the mentality of investing, and it's gate. I'm the gate for your investment.
Now it makes sense to me, Keith. Now, when they talk about gatekeepers, now I understand why they have.
Yep, absolutely. A usufruct combines the two property rights of usus and fructus. Usus refers to the right to use something directly without damaging or altering it. This is why they have the insurance. Okay? And that insurance, again, is a usufruct. Where is your insurance that they are going to indemnify you or pay you, reward you for their misuse? You have to fight for it in their courts. It's not stated prior. That's what's missing from that statement of live birth. There's no qualification of indemnification and proper use. So they get to use it any way they want, and they don't have to tell you. And fructus refers to the right to enjoy the fruits of the property being used, the profits of the investment. That is, to profit from the real property by leasing it, selling crops produced by it, selling crops produced by you, charging an admission to it. You're the ones that are making the admissions to it, and they get to charge you for it because you're making a false admission, because you don't know who you are and the fact that the name belongs to you and it's been attached to a number of a beast. Usufruct is usually conferred for a limited time period until age of majority. And this is the problem when you turn 18 and you continue the usufruct. Mom already entered it into usufruct, and no one taught you that it's being used in that usufruct. And then when you sign that SS5, that's when they subrogate or rogate. It can be granted, and that's what confer means. It's a grant. So they're just stating the same thing. It can be conferred to the usufructuary. Usufruct is usually granted for a limited time period. It can be granted to the usufructuary or person holding usufruct. They're holding your name, you're holding their card. As a way to look after property until the death of a property owner. And the estate can be settled if the property owner is in ill health, indicating that the property owner is still alive. Settled. While the usufructuary has the right to use the property, they cannot damage or destroy it or dispose of the property. See, you gave them the intellectual property, and you destroyed it by giving it to them in the wrong form and not qualifying it. A usufructuary does not have full ownership of the property because they do not enjoy the third property right. First person, second person, third person. You gave them in third person use by second person name without cognizing or giving them the first name given. You attached it yourself to a last name. Abuses, which refers to the right to consume, destroy, or transfer ownership of the property to someone else. So you, in your natural pose, as a natural person, used an individual person, the first two persons, to turn around and give that property to a third person, a fiction in abstract form. They have no substance. This is why they can't hold assets. They can only hold intellectual property as a data element. How usufruct works. In usufruct, a person or group has the right to use the property of another. They do not own it, but have a contractually sanctioned interest in it. That's all they have is an interest. Okay? This is why the state claims the interest, because you're using the upper and lower case, and it's the United States that owns the all uppercase name, which generally they will post as last name, comma, first name for the admiralty side, denoting that you're still at sea and have not landed on the land. There are two types of usufruct, perfect and imperfect. In perfect usufruct, the usufructuary can use the property and can profit from it, but cannot change it in a substantial way. For example, if the owner of a business becomes incapacitated and gives usufruct to a relative to run the business for him or her, the usufructuary can run the business, but can't sell it or tear down the building and rebuild it. You see what's happening? They're using those data elements and they're reconstructing it by using different grammar styles, and they're rebuilding it and selling it because they don't have to tell you in the usufruct.
Mm-hmm.
In an imperfect usufruct system, the usufructuary does have some power to alter the property. This is them. This is imperfect usufruct. This is why they call it perfecting the title. The state cannot perfect the title. They are imperfect usufruct. Only you on the other side of that dual usufruct can perfect that title and that's done through settlement. Let's see here. The usufructuary does not have, or does have some power to alter the property, such as when a landowner grants usufruct to a piece of land for agricultural use. The usufructuary may have the right to produce crops from the land and to make improvements to the land that would aid in that endeavor. However, the usufructuary does not own these improvements. When the usufruct ends, they belong to the original owner or to his or her estate. Again, remember, equity deems the beneficiary to be the true owner.
Yeah.
Benefactor is the one that gives to the beneficiary. So if the state in their imperfect usufruct claims that beneficial ownership, it's only the number that was attached to the name that was given by the benefactor. Just like a grantor grants something to a grantee. He grants something to somebody, the person that is granted to becomes the grantee, who can then hire contractually a trustee to administrate the estate for the beneficiary. Usufruct is only recognized in a few jurisdictions in North America, such as Louisiana. As an example, if a party has a usufruct in real estate property, they have the full right to use it or rent it out and collect the rental income without sharing it with the actual owner, as long as the usufruct is in effect. Sound familiar? Usufruct example.
Yeah.
Bert has granted usufruct over Helen's property. Helen's property is a bed and breakfast with a large yard that needs tending. Helen is in ill health and can no longer tend the property and run the business. Bert, as a usufructuary, has the right to use the property and run the business on Helen's behalf for the time of the usufruct in effect. The usufruct may be in effect until Helen's death, when the estate will be settled and the property will be passed on per act of law or the directions in the estate. See how it says it's settled and directions.
In direction.
Okay? And notice it doesn't say died, but the property will be passed on.
Mm-hmm. So Keith, then the directions would be passed on to a director who is supposed to perform the functions of that particular office?
Absolutely. I'm here as director of the last will and testament of my father, so I can settle his private estate. I only need assistance of the proper procedures. That's it. The next one, we're going to look at the Merriam-Webster's Dictionary of Usufruct. It says one having usufruct of property, or usufructuary, one having the usufruct of property. In other words, it's the use and benefit of property. One having use or enjoyment of something. Example of usufructuary in a sentence. Courts have deemed that irrigators have usufructuary right, a type of property that allows use of something in public domain. A type of property right that allows use of something in the public domain. There is no other way to have a usufruct. That's why if you're going to have a usufruct in the public domain, you have to have commercial contracts sustaining them. Period. Those findings should reference the canons of construction that apply to Indian treaties and whether the Indians understood these treaties as guaranteeing usufructuary rights. Again, they took the native people's interest in the land and its use without profit, but just natural use, and did a condemnation process through usufructuary. So again, it's the same thing with that person. They condemn your person for their usufructuary, and that's the imperfect titling, because that title says it's a decedent, when in fact you are alive, and you, as the living soul, are the only one that can write the title in salvation and perfect it and merge it to a new name. It's the only way. The next one is from L.I.I.W.E.X., and it talks of letters rogatory. Since we're talking about subrogation, what is letters rogatory? Letters rogatory are the means by which a court in one country requests the judicial assistance of a court in a foreign country. Letters rogatory are the means by which a court of one country requests the judicial assistance of a court of a foreign country. The Judicial Officer Department is a neutral and independent forum within the United States Postal Service, who is the registered agent, comprising of the judicial officer, the administrative law judge, and the Postal Service Board of Contract Appeals. Because in the usufruct, you signed a contract, SS5, as a commercial paper and didn't qualify it, of assigning the Social Security as a holder of the name for which they attached a number so you could receive in exchange a card that you now hold in usufruct. And those, again, you're foreign to that United States. You are not a United States citizen. You are not a resident. Generally, the requests are to assist with service of process, the procedure, or the production of evidence located in the foreign country. For example, a German court may send a letter rogatory to the United States court requesting that the United States court take the testimony of a witness residing within the court's jurisdiction and transmit a transcript to the German court, also referred to as a letter of request. Okay? Is that making sense to everybody so far?
Yeah, it is.
Yeah.
It's filling
It
in
is making a lot of sense. Now,
it's filling in perfectly with everything that's been said so far.
right.
Go ahead, dear.
Does LLI.WEX, do they have a statement for a letter of request that you
No,
can
they're just gonna
access?
no, they're just gonna give you. They don't have any templates. It's just plain writing of the definitions that they use in the codes.
Okay.
Now the next one is another Investopedia, and now we're going to talk about equitable subrogation. And again, equity deems the beneficiary to be the true owner. However, that true owner is not the actual owner. Like I said, the benefactor is the one that gave it to them. So therefore, the benefactor is the grantor, and then as they granted it to them, the state becomes the grantee, and by grantee, you fill out the SS5, and lo and behold, the grantee now has a contract for a trustee. Equitable subrogation, a legal principle allowing a party that has made payments on behalf of another party to lay claim to the recovery of damages or funds from a third party. So, Article 3-402 of the UCC, wherein it states, as Iman was talking about earlier, that oops, guess I wasn't showing that, was I? Article 3-402 of the UCC says very clearly the authorized representative giving an unambiguous authorized signature on the instrument is therefore not liable for the person named in the instrument. So on behalf of the party in the instrument, you have been signing all these documents, making all these payments on behalf of the person. And now you can lay claim to recovery of those payments that you shouldn't have been making to the Social Security Administration. That's where it all starts.
The subrogation, did you want the subrogation from Investopedia up there?
That's what we've got.
Okay, okay.
This is Investopedia. It's right here at the top.
Okay.
And then equitable. And now it says, what is equitable subrogation? Equitable subrogation is legal doctrine that allows a party that has made payments on behalf of another party to lay claim to the recovery of damages or funds from a third party. You paid into all those things. You sent your kids to school, and you used the name and number to enter them into that school. And if you had to pay anything for that school, you should get those funds back. Okay? You did it in a representative capacity. Equitable subrogation is a legal concept that allows one party to replace another party when it comes to a legal right. That's that signature. If you don't qualify it, then you have handed over rights, titles, and interest to the property. That's a legal right. It is most commonly associated with the insurance industry. The enumeration at birth for insurance purposes, wherein they develop and construct a burial trust to ensure that if either party, the mom or the baby, or if for God's sake, both parties die, they will be buried appropriately. Specifically in relation to settlement of claims. Equitable subrogation is considered equitable because one party pays the obligation of another party. So if Keith Little has been paying the obligation of the obligor, which is identified by the number that was attached, and it is their number, they're the ones that's obligated on it, not me.
Mm-hmm. Mm-hmm.
The party that pays the obligation is referred to as the subrogee, as our brother showed in the video at the beginning, and the party that has its obligation paid is called the subrogor. The state Social Security, in all cases, is the subrogor right from enumeration at birth. Breaking down equitable subrogation. Equitable subrogation is one of the key elements of modern insurance policies and the process of claiming and paying out insurance. So again, folks, you are the one that's making the payments, and by the signature being an endorsement as meaning an amendment to an insurance policy, you are making insurance payments. Individuals and businesses purchase insurance in order to protect themselves from specific risks. They pay a premium to the insurer for this protection, with the insurer indemnifying the insured for the risks covered in the policy. So again, if you can qualify the signature with no liability, then you don't need insurance. Do you understand this, people? Is there any question on that? Is there any question on the fact that you are not required to have insurance? You just need to learn how to qualify the signature.
So once you qualify the signature, the bill is tendered. Am I correct?
If you qualify it correctly, yes. And again, there is no liability. That means indemnification, and it should be equal consideration, equal benefit, and therefore no parties need to be required insurance. And what goes out comes back. You receive your credit back. They get to use your credit to make a little profit on it. Now they can work with that in their little gambling game. But you give me my motherfucking chips back.
It sounds like 3-card Monty.
Absolutely. Absolutely.
Right, because no party's in hazard, right, Keith?
Correct. If you're qualifying it properly and it's routed directly, of course there is no indemnification, or there is no insurance, because you're qualifying the indemnification. So the next part says the insurer is responsible for settling the claims. So if you file an insurance policy and you are the insured, the insurer settles the claims. That's your right. It's your right to settle the claim. But by doing so, you hand that right, title, and interest in that property to make that claim and settle it, that are made against the policy. Not the law, but the policy. Everything's policy. It's not law. Everything's insurance. It's nothing else. In some cases, such as floods, there is unlikely to be a third party to be held responsible for the damages. In other cases, however, the damages may be caused by a third party. In such cases, the insurer will pay the policy holder for the claim, and in return will retain the right to sue the third party. So if you get in a car accident, they will pay you to go get a new car, but they will go after the other party and sue them and get much more than what they gave you by dealing with the other party's insurance. And that is available through the Social Security, whether that person is insured or not. Everything is probate, and they will get what they want, unless there is a waiver of subrogation provisions. If you wish equity, you must first come with equity. You must learn what subrogation is and waive it. I am not giving you the rights, titles, and interest in my property in a usufruct. I know it's usufruct. I will give you a bailment. Remember our discussion about bailment? This is a bailment. I will give you temporary use, and when it's done being used, it comes back to me. For example, a homeowner purchases homeowner's insurance from an insurance company. The neighbor of the policyholder loses control of a fire outside their home, and the fire ultimately causes damage to the policyholder's home. The homeowner files a claim with their insurance company, and the insurer pays out the claim so the homeowner can fix the property. When the claim is settled, the homeowner cedes their right to sue the neighbor over the insurer, who can then sue the homeowner to recover funds lost from paying out the claim. Non-insurance uses of equitable subrogation. In theory, and again, you have to create your own remedy in equity, so it only is in theory. And this is why you have to be of sound mind, so you can express the theory that you hold for settlement as your remedy privately, not subject to any other public venue, not subject to any other public cases, not subject to any other cases, period, but yours privately and distinctly, specifically. The concept of equitable subrogation can apply to a number of situations involving liability. But in practice, it only applies in cases in which one party has set up an agency relationship with another party. So again, in theory, if it was a Social Security that was a number that was attached to the name to create an identification of a record, goodness gracious, that permeates everything, and that is the insurance. You use that same insurance number to get a driver's license or state ID, so that you can then go out and fill out an employment application and get a job. And of course, in order to get back and forth to that job, you got to go get a driver's license so you can drive. You're giving up all this information, and every last one of them is an insurance contract. Every last one.
So is the Social Security Administration, are they the insurance? It sounds like they are the ones with the insurance as well as the one who are distributing the use of the credit, and it would have to be settled directly with them. Am I correct or am I off?
Well, you have to settle with them, but only as an inclusion, because again, they're funded by the United States. Everything the state gets is funded because they ceded their jurisdiction to the United States. Remember, they can't coin or mint their own money.
Right.
They have to be funded by the United States. That's the reserve banks. And that's a private investment. Oops. So as we go on, that means if one party is legally acting as the agent of the second party, that first party could be a subrogee by paying the obligation of the third party to the second party. In practice, however, this situation would be more likely to go to court, and the third party would be required to pay the second party directly. See how that works? If one party is legally acting as the agent of the second party, you as benefactor, okay, are acting as the first party, and then the second party as well. You gave the information to the Social Security Administration as the first party. And because you're acting as the agent of the second party, the Social Security Administration, the third party identifies the beneficiary by name and number. So you're paying the obligation of the third party. That the first party could be a subrogee by paying the obligation of a third party to the second party. And that's what's happening. You're paying the obligation of the third party to a second party. In practice, however, this situation would be more likely to go to court, and the third party would be required to pay the second party directly. Any questions on that, guys? Again, I remind you of Tom Sawyer, Mark Twain, and Samuel Clemens. Samuel Clemens is the first party. Everything else is still fiction. Even his name is fiction. But he is the first party. The Social Security Administration would be the second party. And then the beneficiary is the name and number that they hold record of. And that's the total fiction. Mark Twain is a physical being that does the penmanship, but he's given directions to do so by Samuel Clemens. You're operating as an agent through agency. The next one, I guess I had this one out of order. Letters rogatory, which is a plural noun, a formal written request by a court or judge to a court or judge in a foreign jurisdiction to summon and cause to be examined a specific witness within its jurisdiction and transmit his testimony for use in a pending action. And we're going to look at Didymus. Didymus, compare Didymus. The next one, Didymus. Variance or Didymus potestatum. Testator. A writ to commission a private person to perform some act in place of a judge as to examine a witness. Okay? So it's a writ to commission a private person to perform some act in place of a judge. And again, oops, I guess I didn't show that, did I? Go back. Letters rogatory. And then Didymus brought us to this. Okay? So, if one seeks equity and if one seeks equity, they must do equity. So in these letters rogatory, it's the same thing, but you should address them as a Didymus because you're a private being. A letters rogatory would be an entity to another entity, whereas you get to act as a judge or a foreign emissary or diplomat on the private side. So there's a distinct difference between letters rogatory and Didymus, and this relates to the fact that usufruct and subrogation is a matter of publicity. Okay? So there are distinct differences, and this is why I say it's not execute or executrix or executive, it's settlor. A Didymus settlor. The next one we have is Collins Dictionary for letters rogatory. Another name for letter of request. Letter of request as Didymus. A letter sent from a court to a foreign court requesting judicial assistance. And I have my court. Everybody has your own court. Everybody is foreign to one another. And that's why you court. Court is a verb. It's a meeting. You court with another person to have a meeting of the minds. These examples have been automatically selected and may contain sensitive content that does not reflect the opinions or policies, The order may be made pursuant to a letter rogatory issued or request made by a foreign or international tribunal or upon the application of any interested person. The defendant must explain why the use of letters rogatory or other judicial reciprocity tools are not sufficient and cannot replace actual transfer of the case. Again, remember they said true owner. I'm telling you, you are the actual owner. And their codes and statutes and rules do not provide a remedy for the actual owner. They only provide remedy for the true owner, which is identified in documentation, and you are actually the witness, and the true owner can't witness anything. It's a fiction. So let's take a look at the next one. This is TravelState.gov. Preparation of letters rogatory. Okay? TravelState.gov. United States Department of State, relative to the Secretary of State at the state level, wherein that's through the enumeration at birth. Secretary of State is who you contact to get a birth certificate. Bureau of Consular Affairs, and it's the Bureau of Vital Statistics that holds all the data elements, and that is regulated by the Department of Commerce. U.S. visa law and policy, Judicial assistance, country information. See how all this information correlates, people?
Yeah.
Summary. Letters rogatory are the customary means. Customary means of obtaining judicial assistance from overseas in the absence of a treaty or other agreement. And it doesn't have to be overseas, it's just from a foreign country in the absence of a treaty or other agreement. Letters rogatory are requests from courts in one country to the courts of another country requesting the performance of an act which, if done without sanction of the foreign court, could constitute a violation of that country's sovereignty. Letters rogatory may be used to effect service of process or to obtain evidence if permitted by the laws of the foreign country. Before initiating the letters rogatory process, parties should determine whether the country where they are seeking to serve process or take evidence is a party to any multilateral treaties on judicial assistance, such as the Hague Service or evidence conventions, or the Inter-American Convention on Letter Rogatory and additional protocols. So that one right there tells you that they are a party because it's inter-American. Okay? Streamlined procedures for requesting judicial assistance under these conventions greatly reduce the time and burden associated with traditional letters rogatory. Parties should also review the Department of State's country-specific judicial assistance papers or pages to determine whether other alternatives are available, such as serving process by mail or in person, or hiring a local attorney to petition a court directly to collect evidence. This is not what we want to do. We do not want to serve. Okay? That's why we keep it private. Time frame for execution of letters rogatory. Execution of letters rogatory may take a year or more. It's not going to happen overnight, folks. I'm telling you. I've spent over 7 years doing this research, and it's going to take me at least another year to get it resolved. Letters rogatory are customarily transmitted via diplomatic channels. Remember, the language I speak, folks, is very specific. That's why I keep it to limited terms. It is not, you will not see these things speaking about execution or executive or executrix. Those are for public estates. A time-consuming means of transmission. The time involved may be shortened by transmitting a copy of the request through a local attorney directly to the foreign court or other appropriate authority if permitted in the foreign country. Judicial Officer Department is a neutral and independent forum within the United States Postal Service. Lists of foreign attorneys who have expressed a willingness to assist U.S. clients are available on the websites of U.S. embassies and consulates overseas. You have a embassy in the state that you live in. One of the people you need to be in contact with, along with the Social Security Administration, Secretary of State, Bureau of Vital Statistics, Governor, Senator, Adjutant General, State Chaplain, all the way up to the federal level, State Attorney. State Attorney is the one that's liable for the common law under the Governor. Drafting letters rogatory. Letters rogatory should be written in simple, non-technical English and should not include unnecessary information which may confuse a court in the receiving foreign country. Many countries have different systems for obtaining evidence and may view U.S. discovery rules as overbroad. Requests for documents should be as specific as possible to avoid the appearance of being overbroad, which may result in refusal of the foreign country to execute the request. This is where I'm going to talk about the Numinant report. You have a decedent Numinant and a live Numinant. You obtain them in two different ways. The decedent Numinant is a request to the Social Security Administration at a specific office location, and the live Numinant is not to be done until you get the decedent Numinant.
So the records that the I'm sorry. The question that I have, so the Social Security Administration, which is an agency, correct?
Yes.
They have Numinant records that they keep on everyone who is encouraged to enroll in their scheme.
Correct.
So how does that work with what the other Numinant that you're talking about?
The decedent Numinant is the financial record. It's going to have every transaction that Social Security number was used for.
So that would be attached to the statistic, the vital, will that be attached to the Agency of Vital Statistics then?
It's all attached.
Okay.
Then the live Numinant is a handwritten request, again, sent to a different location. And I already did a video on this, and you can go back and look at it, and I'll actually even pull it up as part of this continuation here to go over it again in case anything's changed, because I did that video like 4 years ago. But it's very important. That's the record that we're looking at. It's going to have all of the financial dealings of the person throughout the lifetime of the decedent. And then when you're trying to settle that estate and probate through the estate recovery program, you need that information to help them understand what you're doing. So I'll do a review on that, the two different Numinants again one of these days. So the next one, if particular procedures to be followed by the foreign court are preferable, include the specifics in the letter's rogatory. For example, verbatim transcript, place witness under oath, permission for U.S. or foreign attorney to attend or participate in proceedings if possible. This is what I'm telling you. It's private. You do not take this shit to an attorney. Do not involve them at all. Verbatim transcript is that decedent Numinant. It's going to, like I said, it's going to have every dealing that the person was involved with through that Social Security number throughout its entire lifetime. The letter's rogatory should be addressed to the appropriate judicial authority of United States Postal Service, the Judicial Officer Department. The only way to receive equity, indemnification, non-liability, it's a neutral and independent forum within the United States Postal Service that is a registered agent for the Global Postal Trust Services. And it comprises of the judicial officer, the administrative law judge, and the Postal Service Board of Contract Appeals. The SS5 is a contract, and the financial record is the decedent Numinant, and the live Numinant is to affect the estate recovery in probate. The forms of letters rogatory depends on the country to which it is addressed and the assistance being sought. Some countries have statutory guidelines for granting issuance. Statutory guidelines, again, federal acquisitions regulations for the United States says contract terms and conditions required to implement statutes or executive orders - commercial items, commercial services. Social Security Administration is providing a social service of keeping track of all of your financial dealings. And in order to do so, you're operating as an agent and signing all the contracts. Essential elements of letters rogatory: a statement that a request for international judicial assistance is being made in the interest of justice. And justice, as it relates, is the fruits that you're meant to bear. And these people are indulging in your fruits in the usufruct and subrogation. You're just bringing justice. You're making all parties whole. You're not condemning any parties. It's a forgiveness and repentance. Indemnification. A brief synopsis of the case, including identification of the parties and the nature of the claim and relief sought to enable the foreign court to understand the issues involved. The type of case: civil, criminal, administrative. And your civil and criminal records start out with the administrative Social Security Administration. Okay? They have to be able to administrate before they can provide a public record producing criminal and civil data elements that you gave them. Again, you merged with public when you shouldn't have. The nature of the assistance required: compelled testimony or production of evidence, service of process. You're going to produce the evidence, and you're requesting the service of process. Again, to rescind the signature on the SS-5, because had you known what was going on, you would have qualified it properly. Name, address, and other identifiers, such as corporate title of the person overseas to be served or from whom evidence is to be compelled and documents to be served. This is the numinant again. With that live numinant, it's starting the process of serving them notice. A list of questions to be asked, where applicable, generally in the form of written interrogatories. Admit or deny. Admit or deny. There is no birth registration in the United States. Admit or deny. If there is no birth registration in the United States, then there is no record of a United States citizen. In fact, admit or deny. Resident determination must be deemed necessary and not voluntary. Things like that. A list of documents or other evidence to be produced. A statement from the requesting court expressing a willingness to provide similar assistance to judicial authorities of the receiving state. It's a cooperative agreement in equal consideration for equal benefit of making all parties whole, not an accusation or a condemnation. Statement that the requesting court or party is willing to reimburse the judicial authorities of the receiving state for costs incurred in executing the request or executing the requesting court's letter rogatory. Statement that the requesting court or party is willing to reimburse the judicial authorities of the receiving state for costs incurred in executing the requesting court's letters rogatory. In that same request, you merely let them know that you've already paid and you're subrogating through a letter rogatory for the imperfect usufruct so you can perfect the title. Guess what? The title can't be perfected. It can only be salvaged and merged with a new name. Again, the only way. Signature and authentication. Letters rogatory must be signed by a judge. The clerk should not sign on behalf of the judge. It is not a commercial document. Okay? For most countries, the seal of the court and signature of the judge is sufficient. Consult our country-specific information for guidance about authentication procedures for particular countries. This is why the birth certificate and the certificate of live birth is so important. It has those seals on them for full faith and credit already. They're already signed and sealed by the proper authorities, and now you hold those titles to perfect them. And again, it's to merge them with a new name, to make all parties whole. It is itself a peace treaty because their documents, their courts, their administrations, their commerce doesn't allow a private treaty. Those are all public treaties. Therefore, you have to have the ability to create your own remedy, which is a private relief law, your private treaty. Many countries will not accept letters rogatory issued by an administrative law judge. In administrative cases, it may be possible to obtain letters rogatory issued by a federal district court under 28 U.S. Code 1651.
Wow. I just read through those today, earlier. Seriously.
Those are writs. Those are writs. See,
yes, they are writs.
It's not a commercial venture, folks. It's a correction of the commercial transactions. Therefore, this is a writ. 28 U.S.C. 1651, writs. Let's finish this up and then we'll see those writs.
Exactly.
So, translation. The letters rogatory and any accompanying documents must be translated into the official language of the foreign country. So if you're getting their own record, the decedent numitant, it's their own record. It doesn't need to be translated. It is already in the language they put it in. The translator should execute an affidavit as to the validity of the translation before a notary. Number of copies. Forward to U.S. Department of State for transmittal to foreign authorities. So just like all those people I mentioned at the state level, like I said, it's going to go all the way up and down the line, even into the federal. Because these states are operating in REM, which is the thing, the identification that has the person named in it. And it's the federal government that operates in personam. Equity acts in personam. You only have access to equity in the federal courts. The original English version bearing the seal of the court and signature of the judge or a certified copy, a photocopy of the English, the certificate of live birth, and the statement of live birth. The original translation and photocopy of the translation, again, those same two documents. The original documents, again, the same two documents, will be served upon the designated recipient or deposited with the foreign court in connection with the request for evidence, and you're going to give the evidence, the decedent numitant, after you get it, and copies returned to the court in U.S. as proof of execution. For requests involving multiple witnesses in diverse locations, Either prepare separate letters rogatory for each witness or provide a certified copy of letters rogatory for each witness. That's the amazing thing about this internet with electronic communications. You can send it off to the U.S. Department of State, ustravel.gov, U.S. Department of State, and certify everybody you need to contact. Guess what? Remember the vital statistics graph? There's over 500 of them. So you send a copy of that along with the letters or with the decedent numinant and your live numinant with your directive, that birth certificate, certificate of life, statement of live birth and all that as evidence, and then your directive attached to it telling you want the name and number corrected for the payments that you paid when you weren't the obligated party. Fees. The current consular fees for transmittal of letters rogatory are available at 22 CFR 22.1 Schedule of Fees. Again, if you've already made all these payments and you weren't supposed to, that's a rebuttal to this right here. Okay? Bureau of Consular Affairs is one of the departments that's used in that vital statistics thing to do all of this. So why would you pay them again to correct their records? Okay? Again, you're the one giving all the credit. It's already been given. Fix it and make yourself whole in that. You've already taken money that you weren't supposed to. Deduct it from that. Request must include a certified check payable to the U.S. Embassy. Insert name of capital of foreign country, for example, corporate or personal checks, Again, the U.S. Embassy and or the Office of American Citizen Services and Crisis Management in the Department of State will notify the requesting party if the embassy is advised by foreign authorities of any applicable fees. So you need to the U.S. Embassy and or the Office of American Citizen Services and Crisis Management, they need to know that you are one of those American citizens. The record never reflects that. It reflects that you're a United States citizen. And again, there is no such thing.
So then wouldn't you would have to use a bill of exchange in order, because you would have to have some kind of a statement and a coupon to be able to discharge?
No. Again, this is not anything but a writ. And the writ is to correct the record. And the record reflects that you've been paying obligations that are not yours. And by doing another payment, you're paying an obligation that is not yours.
Okay, so that's an error in the record.
Correct. If the letters rogatory request compulsion of evidence from more than one witness or service of process on more than one person, multiple fees may be charged if more than one foreign court is required to execute the request due to multiple jurisdictions. This is telling you they know they operate on multiple jurisdictions.
So would one use the writ of error in order to settle and correct the record?
Absolutely.
Okay.
The letters rogatory and accompanying documents may be submitted to Judicial Assistance Officer, U.S. Department of State. Who's the judicial officer? Wait a minute. The Judicial Officer Department is an independent and neutral forum within the United States Postal Service. So the Department of State Judicial Assistance Officer is within the United States Postal Services for all postings in all accountings of all events incidental to commerce. Cover letter. The document should be accompanied by a cover letter including the following elements. name of case, docket number, foreign country, name of request, service of process, compulsion of testimony, production of documents, etc. Service of process, estate recovery. Nature of request, service of process, estate recovery. And that's handled through the Health and Human Services again, which is the one that creates the Bureau of Vital Statistics, or the Vital Statistics jurisdiction, in which all of these commercial documents are distributed, disseminated. Person to be served or from whom evidence is to be obtained. Name and address mandatory. Phone number if possible. Mailing address of U.S. court or attorney to which the executed letters rogatory should be returned. United States attorney, again, involved. Special instructions. Example, Federal Express account number. You guys got a Federal Express account number?
I don't think so.
Fee enclosed. Deposit enclosed. Again, commercial stuff. Statement of responsibility, statement of obligation, letter of obligation. Look that up. Letter of obligation, if applicable, for additional costs incurred in excess of the required deposit which accompanies the letter. Again, that deposit is the birth certificate. That deposit of the birth certificate is to correct all the records and return the credits that are due the birth certificate, that are due the person.
Keith, I just thought about something that you mentioned about Federal Express. And with Federal Express, whenever you, because I worked for Federal Express and I worked, when I worked for them and people would come in, they already had accounts set up when you would have packages to be picked up and they'll be delivered. So if you couldn't find them under the number, they were listed under the name. So you would have to have the specific name, even though they have, like you said, they might have more than one last name being, or sometimes the name being similar to one name, but you would have to have that specific name in order to access that account number. So an account number would have to be tied to an entity attached to a Federal Express number, just like you would have a name attached. What is that? The name and the number create the record, right?
Correct.
So that would be the same way they did. That's how they would source information through Federal Express when they would ship, because they're a shipping company. And they
Correct.
do receiving and they do delivery, just like you would use, and their paperwork are considered vessels, and those vessels were in triplicates. There was more than one, and you could literally rip it apart. That's how their documents were at Federal Express. So anyone who has utilized Federal Express, they already have an account number with them.
Absolutely. It's like the Social Security, and you go to the state and you get a driver's license. They just attached another account to it. You sign up for school. That's another account. They attach it to the Social Security number. Everything is attached. Every account is attached to the Social Security number. It is the original accounting. And like I said, that decedent numitant will have every transaction in the lifetime of that decedent.
So basically, it's a tree, and on that tree, there's all these branches that create, and those are all the different accounts. Yep.
And that's a perfect explanation of it, because if you look at that vital statistics thing, that's what it is. You got one jurisdiction that comes up. It's exclusive jurisdiction to the individual's name and number. And then from that name and number, all these branches shoot off into everything in life. So let's see here. Transmittal of letters rogatory by Department of State to foreign authorities through diplomatic channels. So you're going to get a hold of your records and everything. You're going to send them to the Department of State with your letters rogatory to have them contact the folks in the state. Remember, the state ceded their jurisdiction to the United States, so they're a foreign entity. They're the foreign country, right? You're an American, right? And that covers the entire continent, right? Okay?
Mm-hmm.
An American is to the land, the continent, not the statutory jurisdictions that it's cut up and parceled out in by imaginary borders. Okay? That's the United States citizen and the state resident. That's for operating in those commercial venues of interstate and intrastate commerce. Letters rogatory generally are transmitted to foreign judicial authorities through diplomatic channels, a formal system of communication between governments. This system is used to transmit letters rogatory to a foreign government so that it may be directed to the appropriate foreign court. Execution of letters rogatory by the foreign court. Foreign courts will generally execute letters rogatory in accordance with the laws and regulations of the foreign country. In compelling evidence, for example, many foreign courts do not permit foreign attorneys to participate in their court proceedings. You understand that? Those attorneys are foreign.
Yes, they are.
And it's the United States that allows them to operate in these administrative courts. I'm telling you once again, and the scripture says it, yo, ye, lo, the attorneys have hidden and taken away the key of knowledge. Why would you want them involved?
And I realized that the other day when I was reading, and we always talk about attorneys and lawyers, until I read something and it said United States Attorney. That's when I realized they are attached to the United States as foreign agents.
Yep. And then it says not all foreign countries utilize services. Again, you're providing personal services as a utility. They are utilizing your personal services. You are the utility.
Mm-hmm.
Okay? Of court reporters or routinely provide verbatim scripts and transcripts. Sometimes the presiding judge will dictate. It is a dictatorship when they start dictating his or her recollection, which isn't verbatim, and they use different words and terms to kind of twist things up of the witness's responses. That is secondhand. That is secondhand. If he's only providing recollection and not going by the transcript, it is secondhand. He may have been there, but if he's only using his recollection, then it is secondhand. He is not going back to his actual observances and looking at that court transcript, but only recollecting him. That is so far off base of firsthand that is pathetic. Return of executed letters rogatory. When letters rogatory are executed by foreign authorities, they are generally returned to the Department of State via diplomatic channels and the Office of American Citizen Services. Okay? Are you getting it? Office of American Citizen Services. They recognize American citizens, but there are so fucking few of them. Everybody's claiming United States citizen. I'm telling you, you cannot be a United States citizen if there is no birth registration in the United States. And if there's no birth registration in the United States, there's no record of it. And if the United States is a debtor and it's located in Washington, D.C., and Washington, D.C. has the 10 square mile physical geographical boundary, then the United States is nothing but the record.
So, Keith, can people that are still utilizing these Battle of the Forms, if they are aware, they can a line veto United States citizen and put in American citizen?
Correct.
Okay.
The requesting party is also notified. At the request of the court, the executed letters of rogatory and proof of service evidence produced can be returned directly to the requesting attorney. Again, that's contradicting what they just said. Not supposed to be using attorneys, but here the United States, because it's their United States Department of State, they're the ones that use the attorneys. Okay? Telling you, they're foreign. That's why they have to use a foreign agent registration. Okay? Example, letters rogatory, name of court in sending state requesting judicial assistance. The Court of the Family Little. Name of plaintiff, Keith. Versus name of defendant. The hospital where you were born. Docket number. The document number on the statement of live birth that your mom signed as an informant. Request for international judicial assistance. Name of the requesting court presents its compliments to the appropriate judicial authority. Name of receiving state, U.S. Department of State, American Citizen Services. And the request for international judicial assistance to obtain evidence affects service of process to be used in a civil, criminal, administrative proceeding before this court in the above captioned matter. A hearing on this matter is scheduled at present for This requests the assistance described herein as necessary in the interest of justice to make all parties whole. The assistance requested, and that party is the United States. It's a relieving of their debt. The assistance requested is that the appropriate judicial authority of name receiving state, United States, compelled to appear the below named individuals to give evidence, produce documents, affect service of process upon the state of Iowa, Social Security Administration, Health and Human Services. Bureau of Vital Statistics. Name all of the state agencies that you've ever had to deal with. The name of witnesses, persons to be served, all of those agencies. Nationality of witnesses to persons to be served, unknown. Unknown. I would not put down, I don't know. I was born a prophet unto the nations. I don't know what other people claim. And I know that if you claim to be a United States national, it means the same thing as a United States citizen. And again, I've told you, and you can look at it and read it as much as you want, but you cannot deny it. There is no such thing as a United States citizen. Address of witnesses, persons to be served. Bureau of Vital Statistics. That was the jurisdiction that was created by enumeration at birth. Bureau of Vital Statistics. They are regulated by the Department of Commerce. And that entire decedent numinant is all of the transactions throughout the decedent's life that was statistically reported in every case. Facts. The facts of the case pending before the requesting court should be stated briefly here. Facts. I signed documents my entire life without qualifying the signature appropriately. I repent and realize that I have caused many errors in the record. I'd like to reconcile the record and help make all parties whole again. I did not mean to create a debt against the United States. I am a friend of the United States. Amicus curiae, in the name and interest of the United States. Qui tam, because I know if I keep signing like this, it will cause more damage. T.S, and the state had no authority to give me authorization to act as a federal, state, or municipal officer or agent. Quo warranto. List any special rights of witnesses pursuant to the laws of the requesting state here. I have the right of equitable subrogation. List any special methods or procedures to be followed. Include requests for notification of time and place for examination of witness documents before the court in the receiving state. Reciprocity, that's that cooperative agreement. Indemnification, no one held liable. It's not a commercial issue here. It's a matter of correcting the liabilities that were placed in error. I did not mean to. The requesting court should include a statement expressing a willingness to provide similar assistance to judicial authorities of the receiving state. So you're not going to compel witnesses or anything. You're just going to gather up the record as you already know it is through the Health and Human Services, Bureau of Vital Statistics, Numinent reports, all that, and reimbursement for costs. The requesting court should include a statement expressing a willingness to reimburse the judicial authorities of the receiving state for costs incurred in executing the requesting court's letters rogatory. And again, if it's being done through the judicial officer department, they are a neutral and independent forum within the United States Postal Service. So there shouldn't be any costs to them either. Let me drop the link in case anybody wants to jump up. And then, of course, signature of requesting judge. You're not the judge. Signature of requester. Signature of requester. Didymus. Typed name of judge. Didymus. Requester. Didymus. Name of requesting court, the court of the family Little. City, state, country, and date. City, state, country. Notice there's no zip code because
No.
it's not part of the zoning improvement plan, which is a commercial zone. Again, this is not in public commerce. This is for private remedy, private relief law. Okay. Any questions on that?
What link was that you read, or is that in the link that somebody can go through and read?
You mean the link I dropped in chat? That's
No,
my
this information that you're reading right now. How would someone locate it? Okay, travel. Okay, state.gov. Okay.
it's both in the private chat and the public chat down below, guys.
Okay. Because Source showed me something today, because I was sitting here and I was smiling because Source showed me a lot of the things that you talked about this day. Source showed me earlier AM, and I went through and read some things, but I have something in my head that I remember seeing and I didn't get a chance to complete it. So I'm going to go and see what that brings me. But literally, when you pull that up, my mouth dropped wide open because I was like, wow, it took me right to that Title 28 today with a lot of the things that you talked about tonight. It's incredible.
Yeah, and that's what we're dealing with, folks. We've got to come together with this information so we can get our minds wrapped around it and figure out what we need to do as far as the process. Because that's the problem. Nobody's understanding the process. So again, equity, if you want equity, you have to bring equity. If you want them to learn, you have to teach them. They don't know it or they refuse to acknowledge it. So you have to know it so you can show them that you know the process. So the next one is what you brought up, the 28 U.S. Code 1651, and it plainly says writs. Okay? Supreme Court and all courts established by act of Congress. That's all of the courts in the states. They all ceded their jurisdiction to the United States, which created courts for them to use in their usufruct. Okay? May issue all writs necessary or appropriate in aid of their respective jurisdictions and agreeable to the usages and principles of law. See that? Usages. That's the usufruct that the states take advantage of the United States. They are themselves in a usufruct with the United States. You give them a name, and now you're in usufruct with them, or they're in usufruct with you. They get to use the name of the United States, and then they get to use your name. You see that? Then they turn around and hand you a nice little card that puts you as the usufructuary, as the agent for the agency. And now you're delegating the funding of the United States. And you're not doing it appropriately, so it creates a debt. An alternative writ or rule, nisi, may be issued by a justice or judge of a court which has jurisdiction. An alternative writ or rule, nisi, may be issued by a justice or judge by a requester of a court which has jurisdiction. You have jurisdiction. It's your goddamn person. Fourth Amendment. The next one, Criminal Resource Manual, Department of Justice, letters rogatory, are the customary method of obtaining assistance, money, property, labor, or services. Obtaining money, property, labor, or services. It's an assistance service. American Citizen Services to assist in the process. Obtaining service on credit. They shouldn't be telling you have to pay a fee. From abroad and in the absence of treaty or executive agreement. Nobody executed the probate will of the testator, mom and dad, who passed on. It was just handed over to the state in probate. Okay? A letter rogatory is a request from a judge in the United States to the judiciary of a foreign country requesting the performance of an act which, if done without the sanction of the foreign court, would constitute a violation of the country's sovereignty. It's verbatim what the last one said. It does have to do with your sovereignty. You do have sovereign jurisdiction over your person. And again, it's from a judge of the United States to the judiciary of a foreign country requesting the performance of an act. And that's a letters rogatory. And that's reciprocity. If you're going to charge me, then I'm going to charge you. So why don't you give me credit for the credit I've already given you? Understand, folks? It's a correction of the record. Hey, you've already gotten credit. You can't charge me any more fees because the credit wasn't applied appropriately, and that's why I'm correcting the records, because I want my fucking credits back. And I need to relieve the debt of the United States in doing so. See, the state's holding the interest in the rights, titles, and of the property, and not the United States. So you give it to the interest of the United States on the account of the United States because they're the original account for the state that creates the Social Security account that you then add yourself to that account. Prosecutors should assume that the process will take a year or more. Letters rogatory are customarily transmitted via diplomatic channel, a time-consuming means of transmission. The time involved may be shortened by transmitting a copy of the request through Interpol. Interpol. That's the international police, and it
Mhm.
extends all the way down to your local police, or through some other more direct route. But even in urgent cases, the request may take over a month to execute. Fifth item, RE translation and transmission. Da 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 da. Yeah, this looks like it's
Yeah, and you see right there in the reading, Keith. Hold on, go back up a little bit. I saw something. Uh, I was just reading it. It was. It said almost. I don't. It was saying who something. No, go back up here it is. It said who is investigating whom and for what charge. That caught my eye.
say that before. You're not investigating me. I'm investigating you. Exactly. It says Office of International Affairs. Assistant United States Attorneys should seek specific guidance from the Office of International Affairs before drafting a letter rogatory. See manual at 281, drafting guidelines. Letters rogatory generally include background, the facts, assistance requested, the text of the statutes alleged to have been violated, and a promise of reciprocity. And remember, the text of the statutes that are alleged to have been violated are your Social Security SS5 application where you violated both state residency for income tax purposes and 19 USC 810. No person shall reside within the zone except federal, state, or municipal officers or agents whose resident presence is deemed necessary by the board. You're not supposed to volunteer it. That's what you need to repent for. I'm sorry, I volunteered the person in surety, and I hate suretyship. I'm sure I made the mistakes. I repent. I need to reconcile the record. It's my fault. Here's the facts. Yeah, and it's as directed by, let's see, letters rogatory must be signed by a judge, normally authenticated by an apostille. This is what they're talking about when they authenticate the birth certificate, an exemplification certificate, a chain certificate of authentication, or as directed by Office of Internal Affairs, a chain certificate of authentication. That's a statement of live birth, the birth certificate, and the Social Security Administration SS5. That's the chain of authentication that authorized you to act as such. It's as simple as it gets. Yeah, that's basically saying the same thing. So let's take a look at the next one, which is that drafting requests for assistance. A request for judicial assistance is necessarily directed to a judicial system that is different from our own. Okay? What is your judicial system? You were indoctrinated into theirs to use the battle of the forms instead of silver and gold or other material assets in private trades. You offered up usufruct with a third party use. Even common law countries do not always have the same legal concepts and philosophies found in our legal system. Even common law countries do not always have the same legal concepts and philosophies found in our legal system. Civil law systems differ even more markedly In drafting a request for assistance, it is therefore imperative to describe simply and clearly the facts of the case and the nature of the assistance requested. Do not use the kind of language that they would include in an indictment or an application for a search warrant. That's saying the exact same thing I keep telling you. Do not make accusations. You condemn yourself by doing so. What you do is you repent and reconcile by cognizing with sound mind that you made the mistakes. Had you understood your true value, you'd have never stooped so low as to only offer up a portion. You would have let your cup flow over. Most applications will be translated. Avoid the use of technical legal terms. ITAR, example, ITAR, ITSP, RICO, or even probable cause, that are impossible to translate. A clear narrative style eases the job of the translator and the judicial authority that receives the request. OIA reviews drafts requests to ensure conformity with these requirements. Grand jury information. Sufficient facts should be included in the request to show that a crime has been committed and that the information sought is relevant to the investigation or prosecution. If the request will not make sense without incorporating information obtained through the grand jury and protected by secrecy requirements, the Assistant United States Attorney should obtain an order authorizing disclosure under Federal Criminal Procedures Part 6E.
So is that why, Keith, they have to put a grand jury trial under seal?
Yes. They know they're in usufruct. They know they're subrogating. And again, you're the one that committed the crime. You're the one that was acting as if though you were an officer or agent of the federal, state, or municipal government, when in fact you were not. That is the crime, if any. And the crime is placing a debt against the United States, nothing more. So you relieve the debt. I didn't mean to. Here's the credits. They're right here. They've been in the book all along. Because letters rogatory are signed by the court, an order authorizing disclosure is superfluous. However, the AUSA should draw the court's attention to the grand jury material in the application. So again, you're not trying to indict anybody, and you're not making any accusations. Again, you're correcting the record, and you're doing so by providing a record, not accusations.
Mm.
So the next one, and I believe it's the last one, yes. This is from ABC Legal. Letters rogatory for international service of process. Letters rogatory are formal requests from a court in one country to an appointed judicial authority in another country, authorized to request service of judicial documents. So when we go back and we look at the, what was it, Department of State? Travel.state.gov, U.S. Department of State, Bureau of Consular Affairs. This is United States, right? So again, if they can't prove by their record that you are a United States citizen, then they don't have evidence that you are domestic, and therefore that itself is evidence that you are foreign to them, and it is a foreign communication, diplomatic. You guys understand that? They don't have evidence that you're a United States citizen. You've been volunteering that and not knowing that it's not true. Same with resident. It's not true. If you don't have an oath of office or a contract that's valuable and valid by knowing and willing intent, then it's not valid.
So does US or United States equate to domestic?
For these laws and codes and rules and regulations, yes.
Okay.
But by your diplomatic notice to them, U.S. Department of State, they're telling you who to contact, American Citizens Services for Assistance of Process. So let's finish up. Letters rogatory are transmitted only through diplomatic channels. Only through diplomatic channels. Again, you cannot do this through the state court. That is considered a domestic court to you because the record will reflect that you're a resident of the state. And in addressing the federal government, you let them know that you are not a United States citizen as the impossibility, and you are not a resident because of that United States citizenship and the term resident as it is under the customs codes. Again, it's customary, and under the customs codes, it's telling you that no person shall reside within the zone except federal, state, or municipal officers or agents whose resident presence is deemed necessary by the board, and the board is the Secretary of Commerce as the chair and the Secretary of Treasury. Those are federal levels. It was never determined. And are received and executed on the basis of comity of nations and reciprocity. And the record will reflect that there wasn't any reciprocity because you never received credit for your performance as an agent. Again, showing you weren't qualified in fact. Because if you were, you would have been in the office of that agent and performing according to a schedule. When are letters rogatory used for international service and process? Prior to initiating letters rogatory process, determine if the country you are seeking to serve process or request evidence from is a party to any other multilateral treaties on judicial assistance. As letters rogatory are reserved as means of obtaining judicial assistance from foreign countries in the absence of a treaty or other agreement. Again, if you're posed as a United States citizen, but you're not, then you're not applicable to those treaties. You have to create your own remedy. In creating that remedy, you are a creator of your own artistic and literal works. That is the Treaty of Berne. Adopt it as soon as you can, folks, and understand how to start negotiating your own treaties. Putting your own judicial determination in them. Stating your own value for your own creativity. Failure to follow the proper diplomatic channels sanctioned by a foreign court could constitute a violation of that country's sovereignty. And I'm going to pull up 22 CFR 93.1 while I'm thinking about it. That's the last one I forgot. This is something I've been harping on for years. This is what's not happening. You're using the Postal Service as a domestic service. And you're using promissory notes, known as Federal Reserve notes, to go down to the post office and exchange for stamps. Why can't you just make your own negotiable instrument? That's what they do. Isn't that reciprocity? So you have the same abilities to contract as they do. And they're doing it all under the global postal trust services. And that is a service that you can obtain on credit by a card that they gave you. Learn how to use it and endorse appropriately. The Director of the Office of Special Consular Affairs in the Bureau of Consular Affairs, Department of State, the Managing Director of Overseas Citizen Service, shall perform the duties of the Secretary of State under 1608A4 of Title 28. If service cannot be made within 30 days under paragraph 3 by sending 2 copies of the summons and complaint and a notice of suit, together with translation of each into the official language of the foreign state by any form of mail requiring a signed receipt, to be addressed and dispatched by the clerk of the court of the Secretary of the State in Washington District of Columbia, to attention of the Director of Special Consular Services, and the Secretary shall transmit 1 copy of the papers through diplomatic channels to the foreign state. In case you guys don't understand that, this is what the state courts are supposed to be doing to you. They're supposed to give you notice as a foreign entity through the diplomatic channels by sending it to the United States, Washington, D.C. Then you're supposed to get something from them letting you know that the state, through its foreign agent, the attorney, has filed a suit against you.
Mm-hmm.
Does that make sense, guys?
I'm
Well,
seeing the correlation now. I mean, a lot more than I did before.
What were you going to say, John?
It's soaking in. It's going to take us
I
some
hope-
time to put all this together, but yeah.
I hope so. But I hope you guys can see that throughout this whole thing, all these different sources, and they're all saying the same thing. And they're saying the same thing I've been saying along. You can take a blank piece of paper. That's commercial paper. Learn how to use it. That's the true usufruct. They made it, but they made it from the land, and the land shall not be sold forever, for it is mine.
Mhm.
Oops. So instead of selling it, they hand you it with something already printed on it, and that's their intellectual property. Now you're in usufruct, and you've been subrogated in that usufruct. The only way out is equity, guys. The only access to equity is federal courts. The only access to the common law, which was merged with equity, is that U.S. attorney. They're bound to the common law.
Just a thought, Keith. I have a question. Since you made mention about the paper being made from the land, correct?
Yep.
And then they took it and they embossed copywritten information on there, so it became theirs, right? And
Yep.
then they give it back to us to utilize so we can participate in their game. Why
Yep.
would we use paperwork to undo what they're doing? Why can't we go back to the traditions of oral documentation?
Well, if you can get out to Washington, D.C. and give them a diplomatic notice, okay.
But couldn't you?
But again, it's a global postal trust service, and they've already obligated themselves to do so. This is Article 1 of the Constitution of the Universal Postal Union. Freedom of transit is guaranteed throughout the entire territory of the Union.
So couldn't you just create an audio like we're doing in video, attention to those parties, putting them on notice and doing it that way?
You can do it through electronic mail.
Yeah. Well, I'm saying if we create an audio like we're doing a video now, attention to those parties that, you know, you say you're no longer participating in the game and now you're putting them on notice that you're now aware of of whatever was taking place, what they created for us to participate in. That's putting them on notice as well, right? You're just not
Yeah,
utilizing paperwork, because isn't that what
right,
was done originally? Everything was done in oral
right.
tradition.
And then when they brought in the paperwork, they found out people are using so much paperwork, and this is what they talk about: frivolous filings. Yet it's the courts that's doing all the frivolous filings. And if you recognize that Paperwork Reduction Act, now they're
Mm-hmm.
moving to the electronic form in full force, and that's a wise thing to do because again, they're tearing down forests to do this paperwork. And if you're going to be a conservationist, you should agree with the electronic form of communication that doesn't destroy the trees to make the paper. So you can do it in video form if you want, but it's much easier done or much better portrayed in text. That way, people like me don't show them my aggressive passion.
I get that way sometimes too.
So anyway, I want to address Daddy's GPT. Had some good stuff this morning. He's got another one. So aren't they committing fraud by issuing passports to people as U.S. citizens if they aren't in fact U.S. citizens? It would be a fraud if you gave them legal notice, which is the first duty in law, to give them legal notice. Hey, I recognized an error. I'm not a United States citizen. I'm not a resident. I was born on this land. I'm a sojourner. And by trying to force that document on me, that is denying me my sovereignty as a stranger and sojourner with him. Our Father which art in heaven, you know, across all of his lands, which are not to be sold forever. And why do we do that? Because in all the lands of our possession, we shall grant a redemption. And in our sojourning, we run across our brethren who have been waxen and poor and sold off their belongings. We may too redeem them by buying them back. It's a matter of redemption. And the only way you can redeem is by accepting repentance. So it's only after you give them knowledge that you are not a U.S. citizen that they try to enforce that you have to have that before they let you out of the country. That's imprisonment. That's denial of your sovereignty to walk with your Father across his lands. And they're all of his lands. It's not this nation's land. I was born a prophet unto the nations, which are nothing but paperwork. So anybody else got anything? I know it's been a long one tonight, 2.5 hours tonight. A lot of information, and I urge you to go back and review it and as much as you need. This is the pertinent information in learning how to communicate that there's been an error, and I'm not accusing you of the error. I'm the one that erred, and I repent. I've been a naughty little boy. My apologies. I didn't understand my spirituality. I was indoctrinated through the public education system. I hope that through the correction of the record and me receiving the credit, I can put it all back into the community by providing a new educational system. Fuck this public one. All right. Well, you got any last words on the way out, guys?
So Keith, you said you have this video tonight and you did one earlier, so we can view both of them?
Well, the one earlier was on Tiffany Henyard, the mayor of Dolton, Illinois. I went over and reviewed a couple more videos on her and the corruption. But tonight's video is more relative to the legal corrections of our own selves. This
Okay.
morning's was just pointing out the various different corruptions that are going on and how we are part of it because we allow it by voting these people in. And that's another thing you're not supposed to be doing. You're not supposed to be partaking in that. You're supposed to be making bond servants of the heathens, and instead they're making bond servants of you, proving you act like a heathen. That's what you need to repent for. That's your sin. That's your crime. You're taking upon the surety of another man. You're not supposed to do that. That's adultery. All right. Well, what do you got,
Thanks, Keith.
John?
This is really good stuff tonight. Wow. I'm going to sleep good.
I hope so, brother.
Or not sleep at all. I don't know.
Well, I hope you get some rest. That's for sure. Whether you sleep or not, that's different. I always like to rest. And I appreciate everybody's input here tonight. It is something that we're coming around to. And like I said, there's other groups that I'm involved with. We're getting very close. We're getting very close. So have patience. And remember, if we don't do it, it's only going to help indoctrinate the next generation into doing the same damn thing that we're trying to solve now. So it's a must that we stand up and do this. It's a must. With that, I want to thank everybody again for your time and support. There's PayPal link down in the details for anybody that wants to share some love. It is certainly appreciated. It is certainly most certainly needed at this point, so I can help upgrade and get other things happening in my life until I get this resolved myself as far as the subrogation, usufruct, and the perfecting of the title. So please help out. And in the meantime, you know, I love you. I don't give a rat's ass whether you love me back or not. And that's to say I don't care if you hate me. That's up to you. So may God bless you and have a good night, everybody.
Night, brother.